If you've ever considered filing a Mandamus lawsuit or you're just curious about how they work, this episode is packed with insights you don't want to miss.
The other issue, though, with that rule of reason is inevitably what happens when you file a lawsuit on mandamus or delay is the government is going to come back and file a motion to dismiss.
Also, does filing the case tend to result in quicker processing or, just more clarity on where the case stands?
So filing a case, especially if you do it the right way and you give yourself as much leverage as possible, does motivate the government to hurry your case along. And the evidence is out there, and if you talk to the attorneys that do this and do it well, they will see a noticeable difference between people that go to court on FOIA and those that don't. And so
Hi everyone, welcome to Immigration and Jobs Talk Show. I'm your host Rajni Bharara, and before I move ahead, let me quickly read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to another episode of Immigration and Jobs Talk Show. Today, we are diving deep into a legal tool that can break through long, frustrating immigration delays, mandamus lawsuits. Ever wondered what your options are when your immigration case is stuck in a seemingly endless wait? We have just the expert to shed light on this powerful legal strategy. Joining us today again is Jonathan Wasden, a seasoned immigration litigation attorney from Wasden Law. John is renowned for his work in challenging government delays and helping clients move forward in their immigration journey. If you've ever considered filing a mandamus lawsuit or you're just curious about how they work, this episode is packed with insights you don't want to miss. So let's just jump right in and learn how mandamus lawsuits could unlock the doors to faster processing. So, John, once again, welcome back to Immigration and Jobs Talk Show. We are glad to have you back.
thank you.
So, John, we are going to talk about mandamus lawsuits, and I'm pretty sure a lot of people already know what mandamus lawsuit is. But for the ones who are not familiar with this legal term, could you tell them what a mandamus lawsuit is before I ask you about other questions?
Sure. A mandamus lawsuit is a lawsuit that's asking the court to order a government agency to do something. And it has to be something that is a non-discretionary governmental duty. And if the court orders and rules in your favor, in this case, it would be an adjudication, then the government has to adjudicate on the court's timeline.
Okay. All right. Thank you so much for taking that up and answering the question, John. And also, I would like to ask that, USCIS can sometime, USCIS processing times can sometime be notoriously slow, right? So, what legal options do applicants have to expedite their cases? Is it a mandamus lawsuit?
So mandamus is one of them. There's two different bodies of law that govern delays of adjudication of government applications. One of them is mandamus. Mandamus comes from the common law. And like I say, it requires that the government has a non-discretionary duty to do something. So that standard is actually kind of high, the way it's written. There's another body of law that comes from the Administrative Procedure Act. And the Administrative Procedure Act says that the government can be forced to do something if their delay is unreasonable. So the APA language of a delay lawsuit seems to be more favorable to the plaintiff. In reality, the courts treat them the same and pretty much interchangeably. So lawyers typically will plead both mandamus and the Administrative Procedure Act. I personally like the language of the APA better. I think it's more favorable to the plaintiff. And so when we plead both of them, we really focus on that APA language.
But John, also, are there any particular types of applications that are more likely to benefit from these expedited measures?
So it really depends on the application. If you're looking at immigrant visa petitions, the law says that the Congress, when they created the Immigration and Nationality Act, expected the agency to make decisions within 6 months on immigrant visa petitions and benefits. For non-immigrants, it's supposed to be 30 days. But as a general rule, no court is even going to give your complaint any attention if it's been pending for less than 6 months. So if you're underneath that 6 months, then it's going to be tough. Now, some cases, like adjustment of status cases, can drag on for years if there's a terrorism-related concern on the government side, and the courts have historically given those adjustment of status cases quite a bit of deference to the agency, meaning they're going to cut the agency a lot of slack in those cases unless you can show that the government is really screwing up.
Okay, but John, also, how effective have these options been in practice, and what success rates have you seen?
So it really depends on how you structure your case. If the common way of doing this with lawyers is they look at USCIS case processing times on the website. They look at the receipt date for their particular case. If it exceeds processing times, in their mind, that's conclusive evidence that the delay is unreasonable, that they have exceeded their delay. When we're talking about the delay cases, what the court's going to look at is some factors that come from a DC Circuit case, a Court of Appeals called track. And the first thing, when you're fighting the government, the first thing you have to show is whether or not they followed a rule of reason. Does the government have a standard process, and are they following their process? And one of the other things that you have to show is, the necessity and convenience of the applicant. Has the agency taken due consideration of those things? So when you're doing your initial petition, if you have extenuating circumstances, it would require you to have a faster decision than, say, some other people. You want to make sure that you provide evidence of those extenuating circumstances so that if you have to go to a mandamus lawsuit, you can plead that the government ignored your necessity and conveniences. The other issue, though, with that rule of reason is inevitably what happens when you file a lawsuit on mandamus or delay is the government is going to come back and file a motion to dismiss. And in that motion to dismiss, they're going to say, we have a standard process. We do it first in, first out. This applicant is in line, and what they're asking the court to do is jump them ahead or skip the line. And they make that argument with a declaration from a government official. Now, they have all the evidence and all the information necessary to determine whether or not that official is telling the truth and whether, in fact, that is their process and they're following their process. But you're ordinarily not going to be able to get discovery, and meaning you're not going to be able to get the evidence to show that the government is not telling the truth and that the government is not following their procedure and that they're not adjudicating you first in, first out. So the trick is, how do you get that information? And that's where, the rubber hits the road.
But John, why do you think the government do that? Why do you think the government, delay the processes or rejects the application, because of which, the client has to file the suit?
So why do they take so long?
Yeah.
I guess people have been wondering for centuries why governments are slow and inefficient. You know, that's an unknowable, to be honest. I think it's just that governments are slow-moving beasts. They move at the speed of a glacier, and they have no motivation to actually, kick it in gear and look after the needs and the interests of the people that they're supposedly serving. So mandamus is the only way to, get them focused on what they're supposed to be doing. Now, there are instances where applications just get lost in the shuffle. USCIS is notoriously bad at bookkeeping. They'll lose applications, they'll be on somebody's desk, for months and nobody knows where it's at. There are situations where they might be, scrutinizing your case because there's a confusion of your name and somebody else's name that's on a watch list. There could be all kinds of things going on behind the scenes that are never disclosed to the court if you don't get discovery. But there's a way that you can get that information that you need, and that is the Freedom of Information Act. Before you file a mandamus case or a delay case, you really should be filing a Freedom of Information Act request first. And in that request, you're going to be asking for information to show whether or not the government has a processing procedure that they follow, and what the data is to show whether or not they have followed that procedure in your particular case. Now, when you file the FOIA, the government has a certain amount of time to respond. They almost never make that deadline. If they miss the deadline, then you can file suit on your mandamus case and combined with it a Freedom of Information lawsuit. That will give you access to the documents and the information and evidence that you need to fight your case. And so that's the trick to get around that problem of no discovery, is courts will be far more likely to give you the evidence you need to fight your case and rebut that government declaration if you couple it with a FOIA claim.
Thank you for answering the question, John. Now, I would like to move to another question. So, if you can please explain the difference between filing a mandamus lawsuit and an APA unreasonable delay claim.
So it's really the same thing, the way the courts look at it. On its face, a mandamus case has a much higher legal burden. You have to prove that the government has a non-discretionary governmental duty to do a particular act and that they have failed to act. That non-discretionary piece is very hard to prove as a general rule. The APA just says you can get a court order if the government has unreasonably delayed your decision or your adjudication. It's a whole lot easier to show that something is unreasonable versus something is a non-discretionary governmental duty. But in reality, the courts analyze these as the same issue. And they look at those factors from the track case, and they look and say, hey, does the government have a rule of reason? Are they following the rule of reason? Who do the equities in this case weigh in favor of? Has the government done something intentionally wrong? And what are the needs and necessities and conveniences of the applicant in this case? And has the government properly given weight to those? So whether it's mandamus or APA, the court's going to analyze it the same way using those factors.
Okay. So the government thinks that it is the same, but as an attorney, do you think, is there a scenario where one option is clearly better than the other?
So, academically, I would say the APA is better. But in reality, almost every lawyer that's filing these cases pleads both mandamus and APA. And the court's not going to really, give it a huge difference, one way or the other. But I think when you plead both, you can argue and use the language of the APA, which is far more favorable to plaintiffs than it is under the Mandamus Act.
Okay. So, also, are there any risks associated with choosing the wrong option for a particular case? I mean, because it sometimes happens that we choose a wrong option for a certain case. So, if are there any other, are there any potential risks associated with that?
I think the risk that you face when you're doing a mandamus case is going into the proverbial gunfight with a knife. the government's going to come in, and we know their game plan in every mandamus case that they intend to defend. They're going to come in and claim that they have a procedure and they're following that procedure, but you're going to be powerless to push back on that unless you have evidence. And the only way to get that evidence is through that FOIA process. So it's really critical, if you're going to be considering doing a mandamus lawsuit or a delay lawsuit, to think about questions and data and information you would need to identify the rule of reason, the processing rules that the government follows for your particular visa category. And it's going to be specific to the form and visa category that you're dealing with. It's not going to be a general theory or a general applicable rule to all applications. So you're going to want to focus that FOIA on your case. If you're doing a delay on an H-4, you're going to be wanting to focus on the rule of reason and the process for H-4s. Then you're going to be looking for data going back a year and a half, 2 years, to show whether or not they actually follow that. And then you're going to be looking for the data for your particular case. Have people with the same filing date, as yours, been in the same position as you? Have people with later filing dates been adjudicated before you? And so you need to structure that FOIA claim to get all of that information that you'll want to show that the government declaration is false.
Okay. So, John, how can an applicant determine when it's appropriate to file a mandamus case?
As a general rule, I would say anything over 6 months gets into that range of should we consider mandamus.
Oh,
Then, if you're beyond that 6 month, then we start looking at what's the visa category, what's the form type. If we're talking about an adjustment of status application, if it's been more than 6 months after you've had an interview or you haven't been scheduled for an interview, when you've been current for more than 6 months, I think we can start looking at a mandamus case then. But
okay.
every particular visa case is going to have its own little twists and turns, and it's going to have its own peculiarities.
Okay. It depends upon your case to case, but normally, if it is more than 6 months, then you can file a mandamus lawsuit, right?
That's the rule of thumb, and I don't think any court out there in the US is going to give you a whole lot of attention or a whole lot of benefit if you file a case with, less than 6 month wait.
Okay. Thank you again for answering the question, John. And now I would like to know, what does the rule of reason play in deciding whether to pursue a mandamus action?
So the rule of reason is, what is the government's process for adjudicating applications of your particular type? In 99% of these cases, the government says their rule of reason is processing first in, first out. And so what you need to do is figure out whether or not they have followed that rule of reason in your case. Sometimes you can get anecdotal evidence from friends or from colleagues that people with receipt dates that are later than yours have gotten adjudicated before you. That's very useful to have, but the government can try and weasel out from underneath that and say, oh, well, your case is unique. There's additional information that we need in your case. And so, again, here is where FOIA is important. By looking into what the government needs for your particular case and why your case might be special, you need to include requests for things like that in your Freedom of Information Act request.
Okay. So also, how is the rule of reason assessed, and what does the court typically consider reasonable?
The rule of reason is not so much a matter of time as it is a process. Does the government have a way that they claim to do things? Internally, do they have procedures for how you're supposed to adjudicate cases in terms of timeline? And then the next step is, are they following that, that process that they claim to have in your case? And like I said, the most common rule of reason that the government's going to point to is first in, first out.
Right, right. And also, John, how do factors like applicant's necessity and convenience influence the decision to file?
So again, if you've given the government that evidence in your initial petition, then you can claim that they have failed to do what they're required to do under the law, which is consider those factors. If you have some very compelling reason why you need a decision quicker than most ordinary people, then you can make that claim. Things like life, limb, if there's some real pressing concern. But you need to make sure that that's included with the initial petition. Otherwise, we can't say that the government failed to consider it if you never gave it to them to consider.
Right, right. Okay. Also, John, are there any particular documents or evidence that would strengthen a mandamus case?
So, like I say, if you have anecdotal evidence from friends, colleagues, or just, internet forums, whatever, that people with a date later than your date are getting adjudicated before you, very helpful information to have. Because when the government, files their declaration and their motion to dismiss, if they're defending the case, they're going to claim that you are just in queue and you're being processed according to first in, first out, or whatever the rule of reason is. That anecdotal evidence can be very helpful to you to show that no, actually, they're not following their own rule. To buttress that and make it much stronger, the documents and evidence that you get through the FOIA process will be very helpful.
Okay, okay. Also, I missed one question, John. So, what steps should someone take before filing a mandamus lawsuit?
The most important thing before you go to the mandamus lawsuit part is not just to look at the case processing times and your receipt date. The most important thing you can do is file the Freedom of Information Act request, because that gives you all the evidence and ammunition you're going to need for this fight. The other interesting thing about the Freedom of Information Act request is that it's one of the few areas in law where you are given attorney fees if you're successful. And as minimal and as small as those attorney fees are, USCIS in particular hates giving attorney fees. They hate giving people like me money. And so in order to avoid having to cut me a very minuscule check, they will tend to be way more forthcoming with documents and information and evidence than they would have normally been in a FOIA process that is not, under the specter of litigation.
John, please tell us, what steps should someone take before filing a mandamus lawsuit?
So ordinarily when people are considering mandamus, they look at the posted case processing times on USCIS's website. They look at their receipt date, they do some quick math or on the calendar, and if they've exceeded that, they're in the zone. They think they have a case for an unreasonable delay. When you go to court, USCIS is going to claim those case processing times that they produce and provide on the website are not accurate. And that, in fact, your case is being handled within the normal processing and you're just in line, and they'll tell the court that you are trying to skip ahead of the line with this mandamus lawsuit. So you might have anecdotal information from friends. Their receipt date is after yours, they have an approval before yours, before you got your decision. And so, the question is, how do you get that evidence, to prove that the government's declaration is bogus? How do you show that the government is not telling the truth to the court? And you really have to think about what data and what evidence you're going to need to show to the court that the government is not telling the truth. And the only way you're going to be able to get that information is through the Freedom of Information Act. And the courts are going to be very limited in what information they can force the government to give you in a regular mandamus or delay lawsuit. But in a FOIA lawsuit, the courts are going to be very likely to give you exactly what you're asking for. And so by coupling the FOIA lawsuit together with a delay lawsuit, you create a much more powerful case for yourself and a much stronger chance of success if the government fights your case. You also increase the likelihood that the government will settle your case because you've increased the likelihood of success on the merits at the end of the day. So the very first thing that you should be thinking about before going to court is the evidence you need and how do you get that evidence. And the only way to really get that evidence is through the FOIA process.
Right, right. Thank you so much for answering the question, John. And I was actually about to ask you how can filing a FOIA request as a part of the lawsuit can be beneficial, and I think you already answered that. So I would like to ask a follow-up, and the follow-up is, what specific information should applicants seek through FOIA to help their case?
So internal data, internal memos, anything that shows what the processing for your particular case type is like and what the government is telling its officers they're supposed to do. The other thing you're supposed to be looking for is people who have receipt dates, before yours and after yours. So you're looking for, monthly, quarterly, annual data going back a year and a half to 2 years that will allow you to determine whether or not people with, the oldest receipt dates are getting processed first, or is there some mix up? Is there, just no rhyme or reason to what the government's doing? And so you want to get that, that processing data that will show you whether or not they are actually following their first in, first out processing logic.
Okay, okay. So now my next question is, a little, I would say, complicated. So, John, what should applicants expect after filing a mandamus case against the government? And also, should they be expecting something or should they not expect anything at all?
So if you file a mandamus case without a FOIA claim, you you ordinarily are going to expect that within 60 days of filing your case, the government is going to file a motion to dismiss. And that motion to dismiss will have a declaration from the government officer saying they're doing everything the correct way and that the applicant is just trying to cheat the system by jumping ahead in line. If you file a case with the Freedom of Information Act request lawsuit component, that Freedom of Information case is going to take priority over the mandamus case up front. So you're going to be negotiating with the government or arguing with the government in front of the judge what documents you should receive. And so before they get to the motion to dismiss and provide their what typically is a bogus declaration, you're going to be negotiating what evidence they're going to give you. And that's also going to, very strongly limit what their declaration in a future motion to dismiss on the mandamus case is going to have. If the government fights the case on the FOIA and loses, then they have to pay you your attorney fees, which is something that they absolutely hate to do. It's almost irrational how much they hate it. And they will go to great lengths to avoid having to pay attorney fees. So if you make it past that FOIA claim, one of the things that you can expect is that they will look to settle with you and just to avoid having to pay you attorney fees. And settlement means adjudicating your case within a couple of weeks. So the FOIA claim is really a very integral part of this, and you really should be considering filing one of these, alongside your mandamus case.
Okay, and how long does it typically take to see movement on the case after filing a mandamus lawsuit?
So the government always has the same 60-day timeline.
Mhm.
Once you file a case and they receive it, they get to review it for 60 days. On that 60th day, unless they have requested an extension, they have to do something. That something is going to be either filing a motion to dismiss, filing an answer, or settling the case. So if they're going to file the motion to dismiss, they will get a declaration in that 60-day period, and they will draft up their motion to dismiss and file it usually on the last possible day.
Okay, okay. Thank you for answering the question, John. Also, does filing the case tend to result in quicker processing or, just more clarity on where the case stands?
So filing a case, especially if you do it the right way and you give yourself as much leverage as possible,
Mhm.
does motivate the government to hurry your case along in a lot of cases. The evidence is out there, and if you talk with attorneys that do this and do it well, they will see a noticeable difference between people that go to court on FOIA and those that don't. And so you're always better off being aggressive when you're dealing with the government, especially USCIS.
Okay, okay. But John, also, sometimes dealing with the government can also be risky, right? So, is there any risk of government retaliation, such as case denial after filing a mandamus lawsuit?
So that is probably the number one question I get across the board on litigation against the government. Will the government retaliate?
Mhm.
And my experience, both inside and outside of the government, has been the same, is that no, they don't. The first reason is it's illegal. And if they have proof of retaliation, they will get sanctioned by the court, if not worse. And the other issue is just common sense wise, litigation represents a huge investment in time on the government side for which they are not compensated. When you file a lawsuit against them, you're not paying a fee to them to pay for their time like you are with a petition. So you're taking, valuable work hours away from them to handle your case. And if you've proven yourself as somebody who's willing to go to court, then that means you're more likely going to court if you get a denial and you're going to challenge that denial. And so, as a general rule, people who sue tend to
Mhm.
get treated actually better than those who don't, because they're a pain in the side. They don't want to deal with you, and they don't want you creating extra work for them. And so they try and avoid you as much as possible.
Right, right. Okay. So, but John, also, have you seen cases where filing a lawsuit led to a negative outcome? And if so, how often does this happen? I mean, you have said no, it very rarely happens, but have you seen a case like that?
So the only time that I've seen somebody get denied is when the merits of the case just legitimately did not warrant approval. And if the evidence is there and the merits are there, the case will get approved. I've actually seen cases that weren't that strong, but they filed suit anyway, and they got approved. So I would say the lawsuit doesn't hurt your chances of getting approved. The other thing to consider is that, let's say you file a mandamus lawsuit and the government denies your application. It's very easy at that point to amend your complaint to challenge that denial. You're already in court. It's just a quick few minutes at a keyboard to change that complaint to challenge the denial. And the government's aware of that. and they'll be facing, additional work time dealing with your case when they really don't want to be. So because you have, access to the courts already, and you're very quickly able to get into court, they don't really tend to do anything negative against your case unless the facts just really do not warrant it.
Okay, okay. But John, also the governments are really unpredictable, right? You can't really predict what they are going to do. So if it at all happens, are there any safeguards to protect the applicants from potential retaliation by USCIS?
Yeah, there is. I mean, the first one is anytime USCIS adjudicates a petition and denies it or revokes it, they have to provide a written explanation that's based on law and fact for that denial or revocation. If they don't articulate the law, the legal basis for what they're doing, or they don't have facts or evidence to support their decision, a court will overrule them and say that they did it wrong and that their decision can't stand. So if you've got everything you need on the merits of your case, if you've got the evidence that warrant approval, there's really not much they can do to deny your case, because when they're writing that memo explaining their decision, they wouldn't really have anything to explain. They would just be shooting, throwing darts against the wall. So that is your safeguard right there.
Okay. Okay. Um, Thank you so much again, John, for answering the question. Also, another question to you is, in your experience, how likely is the government to settle a case to avoid litigation?
So again, I think if you structure your complaint and your case well for federal court, your odds of success are much higher.
Mhm.
And if you just say, hey, here's the processing times on your website, here's my date, therefore I win in your complaint, they're going to fight you and they're going to push back very hard on you. So you need to bring more to the table. You need to bring more to the fight than just that trite analysis of processing times and an application date. And if you do that, if you show the government that they're in for a fight and that it's going to be costly for them in terms of time and money in the FOIA process, then the odds of settling are much higher.
Okay. The government really don't want to waste their time, but also sometimes they don't care if the time of the person, if a person is getting wasted, right, John?
Yeah.
What do you think?
Yeah, the government is an irrational beast. I mean, governments the world over are all the same. They do things that deny explanation or deny logic from the outside viewer. But one thing I think we can all recognize the world over is that government employees aren't going to do extra work for no pay. And as a consequence, they look for ways to avoid that extra work. And litigation is extra work for them. So they have just an inherent desire to avoid that.
Right. So democracy for the people, of the people, by the people. I think it should be changed to for the government, of the government, by the government, don't you think?
That would definitely be the USCIS motto. In fact, when they were changing their logo, that's really what they should have been saying they're about.
Thank you so much for answering the question, John. Now I have a follow-up again. What factors make the government more likely to settle a mandamus case?
So their game plan in a regular mandamus case is just to come in with a declaration that you ordinarily cannot contest because you don't have the evidence you need. It's going to be a declaration from usually the chief of a service center saying, we have a processing timeline. We're following that timeline. He's in line. He'll be adjudicated or she will be adjudicated when it's their turn. If you use the FOIA process as leverage to get information that's going to counter that declaration and show that that declaration is not correct, then the government's going to be far more likely to settle with you, because they'll know that they can't just come into court and be creative with the facts and say that they're following the rules that they normally follow and that you're just in line like you should be. So if you have that FOIA case, that makes them far more likely to settle with you.
Wow, great. Also, John, we talked a little bit about this, but I would like to again get an answer from you. So, is it possible for applicants to recover attorney fees from the government in mandamus cases?
So for FOIA cases, yes, if you get a court order in your favor, the law requires them to pay your attorney fees. There's a schedule for how much they're supposed to pay. That usually motivates them to try and settle with you before the court order if it looks like they're going to lose, so that they can avoid having to pay. There's also something called the Equal Access to Justice Act, which says that the government, if they fight the case all the way out to the end and a court makes a decision, then if the court finds the government's defense to have been unreasonable, the plaintiff is a prevailing party and they are eligible to recoup their attorney fees from the government. Again, that's another thing that the government really hates to do. So if it looks like their case is going south, they will be far more likely or motivated to settle to avoid paying attorney fees.
Okay. But what are the conditions for recovering attorney fees and how often does this happen?
So the court has to decide that you are the prevailing party, which means that you were right on the law, you were right on the facts, and then the government was off base and they shouldn't have fought the case and they shouldn't have wasted the court's time, basically. And so once you do that, then you're eligible for EJA. Then you have to show, as the attorney, then it's on us to show the number of hours that we worked on the case and whether or not the amount of money that the government's saying that they should owe us is accurate and feasible. And the court will look over, billing records and hourly logs and decide, what the correct fee should have been.
Okay. And are there any strategies to increase the likelihood of recovering these fees?
So highlighting, bringing in, let's start that one over again. Say that again.
No, so I was saying that, are there any strategies to increase the likelihood of recovering these fees?
Yes, preparing your case so that you are able to show that the government's declaration that they're going to file that motion to dismiss is false through the FOIA process. You really do make your case stronger so that if they fight it all the way out, the court's going to see that they were being creative with the facts. And if the court doesn't trust the government and rules against them, your odds of getting attorney fees just have, gotten exponentially better.
Okay. Again, so thank you so much again for answering all the questions, John. One last question before I wrap this session up. If a mandamus lawsuit is denied, what are the applicant's options?
You can appeal. Yep. And then, that's probably not very favorable just because by the time you go through the appellate process with the courts of appeal, you're probably going to get adjudicated by that point. The other option you've got is you could refile a mandamus case, after waiting a little bit longer. If they still haven't adjudicated your case and you have better evidence the next time, you can bring it again because you're fighting a different delay at that point. And so that's really the universe of your options.
Okay. Thank you so much for answering all these questions, John. It was a great discussion. But before I let you go, one last thing I would like to know from you. So, have you ever handled a mandamus lawsuit case where you have helped a client, filing the suit?
Yeah, like hundreds of them for especially, back in the 2022 era when we were fighting the H4L2 delays, where the government was, taking upwards of a year to process H4 EAD and H4 extensions. And not only did we get people processed and get their EADs and their extensions done quicker, but we were also able to change policy and change the way that USCIS itself functioned as a result of those lawsuits and a settlement that they entered into with us. So there's a lot of power in these lawsuits. Sometimes it's just about you and your case, but sometimes your case can actually impact nationwide policy and benefit everybody out there that's in your same situation.
Wow. Okay. That's great. Thank you so much again, John, for answering all the questions. And, it's been a really insightful discussion. So, a huge thank you to you. And, guys, to you, I would like to say that if you're dealing with an immigration case that's been stuck for too long, so, what you have to do is you directly have to get in touch with Attorney Jonathan Wasden at 844-592-7336. I would like to repeat this number, 844-592-7336. And you can also email him at john@wasden.law, and you can visit his website, which is wasden.law. Right, John?
Yeah, thank you.
Yes, so guys, do reach out to John and his team. They are doing an amazing job helping a lot of people with their immigration cases. So you can be one of them. So get in touch with them. And thank you so much, John, again for being here. And, hoping to see you soon. Great. So, guys, like I said, if you're dealing with an immigration case that's been stuck for too long, get in touch with John. And today's episode showed us that there's more hope than we realize. So, don't forget the power of the legal system can sometimes be the push needed to get your case moving. So, thanks for tuning in to Immigration and Jobs Talk Show. Be sure to subscribe, leave your questions in the comments below, and we'll see you next time with more expert insights on immigration and job related issues. Stay informed, stay empowered. I'm Rajni Bharara signing off for now. Keep on watching and keep subscribing to Immigration and Jobs Talk Show. Bye.